Thank you, Madam Chair. Congratulations to all of you on your nominations. Thank you for being here. And you all should probably thank Mr. Kanter because I understand he's getting the majority of the questions, and I'm going to keep the streak alive. Mr. Kanter, I want to thank you and my staff. We're very complimentary of the time that you spent with them on a variety of questions preceding the hearing. I want to get to a couple of things, and I'll submit the rest for the record if time does not allow. But the Antitrust Division under the previous administration really took a view that the policies of patent laws and antitrust laws were aligned with the mutual aim of fostering dynamic competition, keeping our leading innovation economy moving. But in June of this year, the acting Assistant Attorney General Richard Powell stated that the Antitrust Division is rethinking its approach to the intersection of antitrust and intellectual property. Do you agree that a reliable, predictable, quality patent rights promote vigorous, dynamic competition for the benefit of consumers, and that the Antitrust Division should continue to support patent rights as a key driver of innovation in a competitive American economy?
I was not at the Antitrust Division, still not. And so I can't weigh in on what decision was made and why. It's something I look forward to examining if I have the opportunity to work at the Antitrust Division and Department of Justice. I have tremendous respect for intellectual property rights and the important role it plays. My view is antitrust enforcement authorities should enforce the law and address conduct that has an anti-competitive effect.
I actually maybe drill down a little bit on a couple of questions for the record, but not too many. I intend to support your nomination. I should say that up front. I don't know if my staff know that, but you do. I do have a question about 2019 joint U.S. PTO, NIST, DOJ policy statement on remedies for standards essential patents subject to voluntary FRAND commitments. In particular, do you intend to withdraw or revise that 2019 joint policy statement? And do you intend to change the Antitrust Division's policy as reflected in that policy statement that antitrust law should not normally play a role in FRAND licensing disputes between SEP holders and potential licensees?
Senator, this is something I look forward to examining if I'm confirmed, and I wouldn't want to prejudge any outcome.
Last year, the Justice Department determined after its review that it would maintain consent decrees with ASCAP and BMI to remedy the competitive concerns that arise from the exclusive, collective, and blanket licensing of copyrights. What are your thoughts on whether and when it should be appropriate to lift the consent decrees?
I had the opportunity to work on behalf of some companies who are involved in that matter, and so I'll refrain from weighing in, given that I'm a pending nominee.
Okay, we'll do some follow-ups. I think finally, what's your opinion about whether certain large market players like Google and YouTube have an obligation under antitrust law to make tools like Content ID available on equal terms for all creators?
Without commenting on specific companies or issues that might be pending before the agencies or the courts, I've been a strong proponent of vigorous antitrust enforcement in the technology area, among others.
Thank you. Thank you, Madam Chair.
Thank you very much, Senator Tillis. Next up, Senator Padilla.